A lot of dirty and corrupt cops end up getting caught and then arrested. But what happens when these cops don't learn their lesson and still act up in court? Here are 4 different cases where we find out what happens to corrupt cops in court.
Let me just plea and get it over with for everybody. Plea to something that I absolutely do not feel good about, but I don't want you to try to send me to the penitentiary for years and years. If you can sleep with it, I can sleep with it.
This is Sheriff Todd Pate, a long-serving law enforcement figure in Breckinridge County, Kentucky. On 15th of March 2019, Sheriff Pate's actions led to a series of events that shook the community to its core. Reports indicate that Sheriff Pate, while under the influence of alcohol, engaged in reckless driving, causing a severe accident that left one individual seriously injured and endangered the lives of several others on the road. The incident marked Sheriff Pate's second DUI offense, with a prior arrest in October 2015. And on the basis of that incident, he was taken to court.
I have previously been tendered executed documents by Mr. Pate that have been likewise signed by his attorney and by the Commonwealth. It is my understanding that through felony mediation that an agreement was reached, that agreement was subsequently reviewed with the victims in this case as well, and that the purpose for today's hearing was to enter that plea consistent with those executed documents. Perhaps I should have directed my questions first at you instead of Mr. Pate. At this point in time, what is Mr. Pate's decision with respect to proceeding forward with entry of his guilty pleas?
So I believe he's still under oath, and I believe I'll just let him answer that question if it pleases the court.
All right. So, Mr. Pate, what is your position today with respect to entering a guilty plea here, consistent with the executed documents that have been tendered to me?
Can I say a few things, or?
I need to understand what it is that we're doing here today, Mr. Pate.
Yes, I had every intention of coming in here today and entering a guilty plea based on the mediation that we had. It's very difficult for me to enter a guilty plea to felony-related charges that I've been in law enforcement for 25 years, and never have I ever charged someone with felony charges on a situation pertaining to this that was similar to this.
As mentioned by Pate, he is meant to enter a guilty plea, but is constantly stalling, to the point where his attorney has to cut in.
If I may interject, just if you intend not to enter a plea, don't say very much about the case, because what you say here under oath will be used against you. I'm not trying to tell you not to say whatever it is you need to say, but also want you to remember that if you don't ultimately plead here, whatever you say, I would think that Mr. Chambers will definitely use against you at any further proceeding. Okay?
Thank you. I was just getting ready to do that. So,
sorry, I did not mean to interrupt.
Mr. Pate.
You know, it's difficult for me to enter a guilty plea for a lot of reasons, and I don't want this court to think that I am trying to minimize, take away from, or deflect any responsibility that I had in this situation that occurred. I do absolutely feel like that because of my bad decisions, that this whole case took a turn that it wouldn't have taken had it not been the Breckinridge County Sheriff. It's difficult for me to plead guilty to felony charges where a prosecutor indicts me and immediately after getting an indictment recuses himself. and basically testifies at the grand jury to facts that were not at all. And again, if I hadn't done what I did and drank and drove on March the 8th, I would not be sitting here, nor would anybody else. But I absolutely think I was indicted. That prosecutor said, got my indictment, I will jump out. Then I made an offer based on those indictments on a Monday. We sent an email back to Mr. Chambers' office to not accept, and 2 days later I'm indicted for assault first, one that if you're found guilty you spend 85% of. This was never an assault first case, should have never been an assault first case, but it became that, and it became that to push me in a direction to take a plea. I'm willing to take a plea, but I now understand how some people feel. I've defended the court system many, many times, and still do, but I feel like I'm being very much bullied into doing something that's not right. Now, the gamble is big. Mr. Chambers wants to go to trial and say, let me tell you this, that, and the other, then I'm risking leaving my family, which I did that March 8th when I drank and drove. Thank God I didn't kill anybody. But I want this court to know, I want the people to know, and I want the public to know that Todd Pate holds himself responsible for everything that he did. But it's hard for me to lay down and plead to felony charges that don't apply.
Despite his huge monologues, the court only wants the answer to one thing: whether he's going to enter the guilty plea or not.
Okay, so I think we are back, Mr. Pate, and probably should have stayed in the place where we started. Again, I wanted to give you an opportunity to have further discussions with your attorney. I'm
sorry, ma'am.
No, you don't have.
I'm sorry for.
Eventually, the judge starts to lose patience with Pate.
What I need to, I think we're back to where we were before. Is it your intention today to enter this guilty plea? And I think we're at a yes or no place at that point.
Can I say one more thing? I think everybody in this room wants this over with. And if I could address Blake, I hope you learn from this case I'm not mad at you. I'm not in any way upset with you.
Mr. Pate, we have reached that point now. This is either a yes or no. Are you going to enter your plea or not?
I guess everybody thinks it's funny.
Well, certainly not the people who I think are here with you today.
No, they don't. I've broken everybody's heart. But it's hard for me when I see Mr. Chambers sitting over there smiling. Let me just plea and get it over with for everybody. Plea to something that I absolutely do not feel good about, but I don't want you to try to send me to the penitentiary for years and years. If you can sleep with it, I can sleep with it.
Okay, I think we're done. At this point in time, I think we're done. And so let me tell you where I think we are today, is that we have executed plea documents. Whether or not Mr. Pate has the right to withdraw his plea now that he's executed those plea documents remain to be seen. And at this juncture, this court could not, based on these preliminary statements that Mr. Pate has made, make a finding that this plea is knowingly, voluntarily, and intelligently made. Where I think we are today is that on the one hand, the Commonwealth can, if chooses to do so, to enforce the terms of this agreement based on the execution. Mr. Pate, I'm talking at this point in time.
Okay, I'm sorry. Sorry.
After having enough of Pate's antics, she decides to conclude the session.
At this point in time, I'm going to sustain the Commonwealth's motion to revoke his bond. He's going to be taken into custody today. We will come back for further hearing as to whether or not to go forward with this plea or to set this case for trial. And I will look at additional conditions with respect to his bond at that time. He's going to be held without bond based on, at least at this juncture, there having been an executed plea where he was to serve 75 days with credit served. There will not be any arrangements made with respect to house him in Grayson County or anywhere else, that he will be taken into the custody and housed in the Breckinridge County Jail. And at that point in time, if the Breckinridge County jailer wants to make arrangements with another jailer to house him, he can. And then what we will do is we will look at coming back as soon as your respective schedules will permit, in order to hear argument on whether this case should proceed forward on resolution of a plea, or whether it should proceed forward on resolution for trial, and if by trial, then where that case should be tried. We've got a fully executed plea document that provided in pertinent part that he was to serve 75 days in jail, and he's going into jail today under the terms of that plea. Whether or not proceed forward with the court accepting the Commonwealth's offer of pretrial diversion, as opposed to rejecting that plea, which would give him the opportunity to then, of course, withdraw his plea. We got a whole lot of things to sort out, and we're not going to sort them out this afternoon. So if you'll look at your calendar and tell me when you can be back here next week, I can be here Thursday afternoon, I can be here anytime on Friday.
Despite all of his charges, Pate did not serve jail time due to a suspended sentence and payment of a fine. In the current case, Pate was required to serve 75 days in jail, but with credits, he would only need to serve an additional 29 days, as stated by his attorney, Douglas Vowles. Vowles also indicated that Pate entered into a pretrial diversion agreement, suggesting that the charges would eventually be dismissed. So although Pate did manage to get off easy, but we can't say the same for our next corrupt cop.
Why did you take the money?
I took the money, and mind you, this does not excuse it, but from drug dealers that took it from parents of very poor people in this county. That money, regardless of what the state and what the media has claimed in the past years of a gambling problem and that money being used for gambling.
This is Charles Reeder, the former Pike County Sheriff, once a respected figure in law enforcement. According to court documents, Reeder was found to have mishandled seized property and evidence, even going so far as to set up a straw sale for a seized vehicle for personal profit. Additionally, he admitted to taking cash from evidence, intending to reimburse it later. During his plea, Charles tried his best to get the judge's sympathy, but here's exactly how that plays out.
Your Honor, I stand here before you today to take accountability for my actions. As a sheriff of Ohio, I shed, excuse me, I shed bad light on the office of sheriff. I can only ask that my staff, their families, the community, and my family who is here today will forgive me for the undue stress I caused them. For this, I am terribly sorry. I stood in this court on September 24th and pled guilty to the charges against me, to accept responsibility for my conduct. That day, within minutes, everything that I'd worked for professionally and honorably for 25 years was stripped to me, with nobody to blame but myself. My staff and I had united with the community and had a partnership and trust. And they truly believed in us as a unit, as a whole. And I betrayed that trust. If I could go back and change it, I would 1,000,000 times.
There's another box of Kleenex.
For this is not who I am. Never, ever did I imagine myself on the defense side of this courtroom that I've spent 25 years of my life in this county in law enforcement. As the sheriff, I gave my staff in this community all of me, every ounce of my being. You are aware, Your Honor, that this has affected my mental health as well as my physical well-being. There's nothing left for me to give or to take from me other than my freedom. I am a good person who made bad decisions and choices. I can continue to be a productive citizen in this county and be in the community with the love that I have for my family, my friends, and my neighbors. I'm asking all this so that I have the opportunity to watch my son graduate from high school and attend college this year. My daughter, who's getting married in October, so that I can be there for her. And my wife, so that I can be a husband that I haven't been in 25 years due to my career. Your Honor, please do not send me to prison. I have roamed, but I'm not ruined. I still have a lot of good left in me.
Charles definitely gave an emotional act, but the judge isn't done with him just yet.
Why did you cut open these evidence envelopes and take the money out, and then in some cases you put it back, although you were caught because the envelopes had been unsealed and sealed again improperly, and the denominations did not match what was taken at the crime scene or from those individuals. I guess, why did you take the money?
I took the money, and mind you, this does not excuse it, but from drug dealers that took it from parents of very poor people in this county. That money, regardless of what the state and what the media has claimed in the past years of a gambling problem and that money being used for gambling, was used when there was a tree planted in the name of the Shelton boy. It's at the entrance of Western High School to the left as soon as you pull in. Nobody could pay for that tree. Nobody offered to pay for that tree. A drug dealer did. When schools had cheerleading or pee-wee that had car washes and such, I would have our cruisers taken down there. My men and women did not make good money, so some of them would give them $2, $5. I took money from that and I provided it to those people.
Although Charles seems to be giving some valid reasons, the judge still finds flaws in his statements.
On different dates, officers counting out money, in one instance yourself, coming to $7,000, for instance, and then turning it over, and there was like $600 short.
And ma'am, Your Honor, I advised my attorney I would take a stipulated polygraph on the $1,000 that I provided on that particular case, that the state now has a cashier's check for $1,000 for State versus Carter. At that scene on Rainbow Trail Road, I was with Lieutenant Burchett. It was videotaped. It was videotaped of Mr. Carter opening a locked door. There's a videotape that exists. Opening a locked door so we could prove that that door was locked and that Mr. Carter had a key. We entered that. It was being videotaped by Lieutenant Burchett. Mr. Carter pointed out where those funds were. They were in some sort of little container, if I remember correctly. They were pulled from that container and counted. They were taken to the back of that same F-250 and placed in the same lockbox in that F-250, where Mr. Carter got in the front passenger side of my truck with me. Lieutenant Burchett followed me in his vehicle directly to the office without stopping. We got to the office. I provided Lieutenant Burchett with the entirety of those funds. So where the $1,000 mistake comes in, I have no idea whether it was accounting error. I have no idea, but I would agree to a stipulated polygraph.
Despite all of his reasonings, there is still a reason why Charles is in court, which the judge points out.
But you pled guilty.
I did, ma'am. Yes, Your Honor. And you're asking me, and I'm giving you the explanation.
All right, I want to go back to, all right, in the PSI, the pre-sentence investigation, it indicates what you're saying here as to why you claim you used the money for various charitable community things. And then, but the PSI officer notes that there's no documentation that you used it for those things.
Right, I did not document those things.
Okay, now I want to ask you about this. All right, that's your statement, what you say you used the money for, and okay, that's on record. But I do want to ask you some other things here. Did you lose $3,000 gambling at the Scioto Downs Racino between June 2017 and September 2017?
Yes, not by myself. They have cards. And of course, again, Your Honor, I've pled guilty to this. But they have cards that you put in a machine. I can have a card in my name, and I can have a card in my name that my wife possesses. So I can be at one machine and she can be at the other. And the money that she spends and the money that I spend, they count on the same card and calculate the money as one. Now, the state has my financial records. They will see that when we are at those casinos, and I have not been to one since and will never be at one again, that the money was taken, that our debit card was put in a machine and the money was taken from our checking account.
Well, obviously, that doesn't answer the question, where did the money in the checking account come from? But no.
At that time, I was making the salary of the sheriff, and my wife was making approximately $2,500.
Just asking the question here, that's all.
A pay.
Okay. And the state believes that some of this is due to gambling. I mean, you're talking like over or almost $6,000 in a couple of months that you lost or expended on gambling.
And at that point, we were making almost $11,000 a month. And that again was from my checking account, where it should show my direct deposits, my wife directs deposits, and that it came from our debit cards where I retrieved that money.
Charles is doing his best to throw off the judge, but she has all of her facts in order.
I don't doubt it came from your debit cards. The question is, where did the money come that went into your checking account? I guess that's
where the media reported that I had marital problems, because it came from our joint bank account. My wife made very good money at the time, and I took that money and I gambled.
Okay. All right. That's all the questions the court has.
Thank you, Your Honor.
Thank you.
The final verdict for Pike County Sheriff Charles Reeder was a 3-year prison sentence. This followed his guilty plea to charges of theft in office, marking the verdict of a legal saga that exposed a pattern of misconduct and betrayal of public trust. Charles' case definitely went quite peacefully, something that we can't say for the next one.
It is the judgment of the court that you be sentenced to 6 years confinement in the Texas Department of Criminal Justice Institutional Division. That will be suspended. You will be placed on probation for 5 years. There's a $2,500 fine plus court costs. No restitution is ordered in this case.
This is Michelle Barrientos Vela, a former Bexar County Precinct 2 constable. She was taken to court for 2 felony counts of tampering with records. The verdict came after she presented falsified Rodriguez Park security payment logs during a criminal investigation.
If you could please stand so that we can proceed to sentencing. Mr. Goss, is there any legal reason we cannot proceed to sentencing?
Oh, yeah.
It is the judgment of the court that you be sentenced to 6 years confinement in the Texas Department of Criminal Justice, the Institutional Division. That will be suspended. You will be placed on 5 years probation. There's a 20.
After the announcement of her punishment, chaos broke in the court and it took a while for things to settle.
Close the door.
I did not hear.
I'm going to start over. It is the judgment of the court that you be sentenced to 6 years confinement in the Texas Department of Criminal Justice, Institutional Division. That will be suspended. You will be placed on probation for 5 years. There's a $2,500 fine plus court costs. No restitution is ordered in this case. You will be ordered to satisfy 600 hours of community service. 1/2 of those hours I will allow you to buy out by contributing to the San Antonio Food Bank at $10 per hour. The remaining 300 hours you will satisfy by working for Habitat for Humanity at a location I will designate. There is to be a no contact order with Leonicio Moreno, no contact order with Anthony De La Cerda. I am ordering a $50 contribution to Crime Stoppers. I'm also ordering a moral recognition therapy course. You will complete that course. I will be satisfied if you buy the workbook yourself. I'm not going to require you to go to the group therapy sessions. Confinement. As a condition of your probation, 90 days confinement in the Bexar County Jail. I am going to hold that in abeyance until the results of the appeals are exhausted, but I am ordering it, I'm imposing it once all of that is finalized, and I will decide how you will serve that confinement. I have options. Lastly, your probation starts today, ma'am. Look at me. Your probation starts today.
Michelle Barrientos Vela was sentenced to 5 years probation, 90 days in jail, and 600 hours of community service after being found guilty of 2 felony counts of tampering with records. Although things did get crazy during her case, she remained calm, unlike the next corrupt cop.
I'm going to prohibit your physical or constructive possession of firearms or ammunition at any time for any reason.
This is Joshua Underwood, a former deputy sheriff with the Oconee County Sheriff's Office. On February 28, 2019, he appeared for a bond hearing at the Oconee County Detention Center after a tense situation unfolded at an apartment complex on South Oak Street in Seneca, South Carolina, where Underwood was residing. Underwood was being charged with opposing or resisting a law enforcement officer serving process. And here's how that turned out.
All right, Mr. Underwood, I find the solicitor's request for a cash or surety bond of $50,000 to be reasonable accordingly. I'm going to impose that cash or bond for your release.
After the announcement of his bond, Joshua isn't too happy.
I find it absurd that you haven't even obtained any information from me based off the solicitor. You're going to believe everything that he says.
Okay.
And you're going to go ahead and set a surety bond on me on a misdemeanor.
Okay. Are you finished? Okay. If you'll hear me out, please. Thank you. Additionally, I'm going to place a requirement for a GPS monitor prior to your release on bond. I'm going to restrain or restrict your contact with your domestic partner or the mother of your child, whichever best describes her, to include her place of work and her residence. Additionally, I'm going to prohibit your physical or constructive possession of firearms or ammunition at any time for any reason. And I want to make sure that you understand, when I say constructive possession, I mean there's to be no firearms or ammunition in any vehicle you're being transported in or riding in unless it's...
What grounds? What grounds? Are you prohibiting me from firearms?
I am.
Why? What grounds?
I am. Because I have that latitude given the severity of...
What reason is your
Sir.
stance? Why are you standing behind that you're gonna
Mr. Underwood,
firearms?
Mr. Underwood, in this court, one person talks at a time.
From the solicitor's office and the sheriff's office.
You're going to find yourself in contempt of court.
I've already been in contempt.
Okay.
I'm not here, sir.
All right. Are you going to allow me to finish? Constructive possession of firearms or ammunition means you will not have it in your possession. It won't be in the house or the room that you're staying in. It won't be in the vehicle that you're being transported in, unless we're talking about transport by law enforcement. Do you understand that? All right. That's all. You're dismissed. Officer, if you'll remove him.
You can't look at me, can you? You can't look at me, can you? Which one? Which one?
Joshua continues to talk angrily with the judge while he tries to get him to calm down. Underwood's bond hearing shed light on the legal proceedings following his arrest. A judge set his bond at $50,000 and mandated the use of an ankle monitoring device should he secure his release. Although many of these cops tried to finesse their way out of the court cases, they were eventually given the punishment that they deserved. If you enjoyed this video, let me know in the comment section. And don't forget to subscribe. Goodbye.